Hello, how are you? I am just dropping in here because a beautiful member of the community sent me a post that was done in a local parenting group in Western Australia. And I just wanted to share this because, as a mum myself of teenagers, it has been something that's crossed my mind, and quite a lot of my friends and families that I know have had to deal with similar situations. So it was posted actually a week ago, but I've been, writing notes and looking into the real practical remedies. Yes, anyway, before we start, last Sunday was Mother's Day, and I got lots of really beautiful trinkets and treasures. This is one of them. It's a little strawberry flower in there, and yeah, that made my day. Anyway, just wanted to share that with you. All right, so let's get stuck in. I'm going to share with you the post that was originally shared, and then let's look at the relevant in the real world remedies that we can look at. So the post said, "Good morning. I am writing today with concern regarding my parental rights. Last Friday, my Miss 15-year-old was taken by ambulance to hospital. What I experienced with the AMBOs, emergency room staff, nurses on the ward, and later at the GP is frightening. I was not recognised nor asked any questions regarding my daughter by any of the above people. I have now signed a legal guardianship over my daughter at our GP medical centre. But I want to know, do I need to go to the health department and have it signed off for across the board? What I experienced was horrible. Twice I was asked to leave the room so they could ask her questions about her home life, her social life, drugs, sex, etc. My daughter gave consent for me to stay as she was scared. What I know is that once your child turns 14, you no longer have any rights. I understand the health department implemented this for those children who come from abuse, neglect for their own safety. But to do it across the board is an overreach. How do I register myself as her legal guardian? Can I just get her to give written consent wherever we go? Please help. Any information would be appreciated." Anyway, so my friend actually saw that post in a local group and she sent it to me. Right, so I've been busy diving down the rabbit hole, looking at legislation and administrative policies and procedures during the week. So first of all, thank you. Thank you for raising this, because this is a really deeply important issue, right? On a practical basis, but also emotionally. Basically, what you've experienced really reflects a growing trend, not just in Australia, but worldwide, regarding health and also education systems, where minors, particularly from the age of 14 and up, are given increasingly autonomy under policies designed, to protect them from potential harm. We can go down another rabbit hole about that, but this obviously has serious implications for loving and attentive parents like yourself. So we're going to break this down. We're going to explore your rights as a parent, the current legal landscape, and practical remedies you can use moving forward. This is where I stop and say, I am just a humble mum of two teenagers. This is not advice in any way. This is just sharing ideas, information, hypothetical. It is at your discretion what you do. Okay, so why were you excluded in the first place? So in Australia, and I'm sure other countries have similar standards, it's called the Gillick Competence Standard. In Australia, The concept of Gillick competence is applied to determine whether a minor under 18 can consent to their own medical treatment without parental involvement. This is based on whether the minor is deemed mature enough to comprehend the nature and consequences of the treatment. So, for example, New South Wales Health and similar departments across states generally presume a child over 14 may be able to make independent decisions, especially regarding sexual health, mental health, and substance use. Now, as a mother of two very capable teenagers, I beg to differ about that. I would love to hear what other parents feel like. Please share in the comments. Now, I just want to state that the Gillick competence standard is not a law. It's a policy and risk management position taken by most institutions based on interpretations of case law and human rights obligations. We can hear Harkin is not impressed with this either. So I just gave Harkin a snack. If those of you who don't know Harkin is my little Viking, a griffin. There are some videos of Harkin on my channel. Anyway, so most importantly, let's look at what is legal guardianship and does it help? So you mentioned signing legal guardianship with the GP. Now, it's important to distinguish you are already the legal parent and guardian by default, unless a court has removed that status. Signing a guardianship acknowledgement with your GP might clarify decision making within their service, but it doesn't override health department protocol in hospitals or emergency care or at school, etc. So to formally register guardianship across all systems, it would actually need to happen through the family court or a recognised guardianship order, which is typically used when the biological parents are not the primary carer. Example, in kinship care, foster. And that doesn't sound like that's your specific case. So you really don't need to reclaim parental rights that you already hold, but you do need a strategy to ensure that they are respected in practice. Okay, so this is what I have been looking at. What can you do to practically ensure involvement? All right, so again, this is not advice. I'm just sharing out loud with my friends. So here are some key practical steps. First of all, written consent from your daughter, as you've already stated, and this is highly recommended. So have her write and autograph a document such as, to whom it may concern, I, full name, Sarah Smith, born 13th of the 5th and the year, confirm that I consent to my mother and or father, and then put the mother and father's names, to be present and involved in all aspects of my healthcare decisions. I wish for them to be informed and consulted in and any all medical matters, including mental health treatment and assessment. And then signed, your daughter's signature and the date. So then keep copies printed and signed and bring them to all appointments. Make sure she has one on her at all times. The parents have one on them at all times. Now, you could take it up a notch and get advanced consent for each provider. Now, some healthcare centres or hospitals allow a form to be added to your child's file stating that they want parental involvement. So it's up to you, but you could ask each provider if they have such a form, or make sure this letter is submitted to all providers. Take it up a further notch. Option C, you could also have a health department letter. Now, this is optional, but it could be quite empowering for you and your daughter. You may choose to write to the health department or relevant hospital network with your concerns and request A, yes, Harkin, clarification of policy regarding minors and parental involvement, confirmation that they have received your daughter's signed consent, and a note to be added to her record confirming you are to be included. If you would like a template of any of these things, just message me on my DMs, and I can guide you in the right direction with that. And again, this is not advice. This is just one parent sharing to another parent. Now, we also need to know the exceptions where you actually must be informed, right? If you have a minor. Look, while some matters like sexual health, mental health, allow minors to speak privately with professionals if, right? They are able to do that under current policies, not law, but policies. And we all may have different thoughts about that. And again, please contribute in the comments. So there are exceptions to that. If a child is not deemed competent, if treatment is invasive and requires follow-up, and if the child's safety concerns are about others, not yourself. If those three things are there, or one of those things, you are likely still to be involved, regardless of that letter. Okay? Now, something very important and what raised the concerns at the very beginning is, when is it system overreach? So, fellow mum to mum, I feel that you are right to sense that the blanket application of these policies, even to healthy family dynamics, is unjust. You are not alone. Many parents are blindsided by these quiet policy shifts. Again, this isn't law though. These are just internal policies and procedures of that specific institution. So this is why some families are keeping written agreements on hand, right? They are recording appointments and they are removing children from systems that undermine family trust. And again, that's at your discretion. So my final thoughts. 1, you are still her legal guardian, but the default trust has shifted from family to institution. And that means you must now document everything, including your own daughter's will and intent. Please join the conversation in the comments below. I have beautiful members of the community who send me things in often, so please subscribe to this channel if you're watching it on the YouTube channel. Like, share, and I would really love to hear your thoughts on this topic because I think it's a really important one. Anyway, I will use the back of my notes now for shopping lists, and I hope you have a beautiful rest of the day. Thank you so much. Bye.